I'm now going to move on and introduce Amber Izzo. Amber is the Information and Advice Officer for the Royal Mencap Society, and she's here to talk about legal advocacy and power of attorney for those with learning disabilities. We've had a lot of questions at the association fairly recently about this, and we are really grateful to have someone whose specialism will cover all of these. Amber has also provided us with a really comprehensive resource pack, which she said that can be sent out to anyone who'd like to receive it after this. So if anyone at the end of this would like to receive the pack, if you just email us at admin@PWSA, it's all over our website, we'll send it out to you. Amber, thank you very much for joining us, and I would now like to pass over to you.
Hello, thanks ever so much for inviting me. It's a pleasure to be here. I will share my screen. I have got a presentation to go through with you. I do apologise if I'm looking in this direction. I'm on two screens, so I am still here. So yes, thank you for the lovely introduction. As Susan said, my name is Amber Izzo. I'm an Information and Advice Officer working for Mencap. So I'm here today to talk to you about mental capacity, power of attorney, different options in terms of legal advocacy and making decisions on behalf of your child or your loved one. So I will try and share my screen for you so that I can get the presentation up for you. Okay, can we see that okay? Is the presentation there? Yeah.
We can, it's great, thank you.
Excellent, okay, let me just get that up for you. There we go. Okay. So I thought it was probably best that I started by just explaining who we were. So you can be reassured that first of all, we do know what we're talking about. And if you do have any questions kind of after today that have any kind of relevance, the information is there for you to make contact with our learning disability helpline. We answer all sorts of queries with regards to not just mental capacity, but housing and anything else that may be relevant. So it's my role that when you call the helpline, the way that we work is if the query is a little bit too complex, just to be given a straight answer, you need some further support in any way, shape or form, then it would be assigned to somebody like myself, and we will then get in contact with you and go through your query with you. So everything I'm going to talk to you about today is covered by the Mental Capacity Act 2005. So you may have heard of this, but if not, I thought I would cover the basics with you so you understood where this was all coming from. So the Mental Capacity Act is a set of laws that's designed to protect and give power to vulnerable people who lack the mental capacity to make their own decisions. They are absolutely pivotal in safeguarding the lives of people who may lack mental capacity, and it applies to everybody over the age of 16. So it doesn't just exist to protect vulnerable individuals, but it also acts to empower people to make decisions for themselves as much as possible regarding their own care and treatment. The same rules apply whether the decision is a life-changing decision, such as whether or not to have a major surgery, life-saving treatment or anything similar, or whether or not it is an everyday decision, such as whether or not to have Weetabix for breakfast or whether or not to wear the pink socks or the blue socks. It is always relevant. So to determine whether or not somebody has the mental capacity, a mental capacity assessment would take place. It isn't necessarily a formal assessment. There isn't, like with many things, like with a needs assessment, there would usually be paperwork to fill out and certain conditions that need to be met. A mental capacity assessment doesn't always take place in that format. Like I say, you may complete it every day in deciding whether or not your loved one has capacity to decide what they want for breakfast, or like I say, any kind of formal decision. So we will cover this more as we go. So there are 5 principles to the Mental Capacity Act that have to be followed. They are, as you can see on the screen, you've got presumption of capacity, support to make a decision, ability to make unwise decisions, best interests, and finally, least restrictive. So I'm going to go over each of these with you that explain the principles in a lot more detail. So the first one is presumption of capacity. So this means that you must always first assume that somebody has the capacity to make their own decisions. It isn't something that can be assumed based on a person's age, their appearance, their diagnosis, or their behaviour. Someone with a learning disability, for example, has just as much of a right to make their own decisions as someone who does not. This is where it's also really key to remember that just because somebody has previously lacked capacity to make a decision, it doesn't mean that they still lack it. They can regain capacity, and capacity can change depending on the question. So it's really, really important that we presume a person has capacity. Like I say, if somebody had a really good example, I think, is that you presume that somebody has capacity. If they lacked it previously because they were under the influence, for example, it doesn't mean that the next morning they would still not have capacity to answer that question and make said decision. So the next principle of the Mental Capacity Act is that everybody should have support to make a decision, meaning that all practical steps should be taken to help a person make a decision themselves before deciding that they don't have the capacity to do so. So, for example, if they are less alert after taking certain medications, then you can ask them when it's worn off. Or, for example, if they struggle with verbal information, but they can take information in a lot better if it's written down or it's really colourful and different things like that. It's really important that we explore different ways of explaining that information so that you are supporting them to make that decision themselves rather than asking them once, and if they don't understand it, that's it. So, like I say, you can find different ways of explaining it, or you can break the information down and talk about it over a prolonged period of time so that they're more likely to understand it. So like I say, we need to make sure that somebody is given as much support as possible. Just like you wouldn't pose a question to somebody in English if, for example, the only language they spoke was Spanish. You would get an interpreter and support them to understand what you were asking. So it's exactly the same with somebody who perhaps has any kind of additional need. The third principle is that everybody is able to make an unwise decision, and often this is the principle that poses the most confusion or difficulties for families and carers, as it can be quite tricky to accept when in practice. So all adults have the right to make a decision that somebody else may deem to be unwise or even eccentric. Just because somebody is making a decision that you would disagree with or you wouldn't perhaps make yourself, it doesn't mean that they don't have the capacity to make that decision. The most common example here, as I've said on the screen, would be smoking. So we all know it's not a very nice habit. We all know that it has negative health effects. However, somebody has the right to make that decision. And if they are aware of the effect that that would have on them, if they want to carry on smoking, they are well within their rights to do so. We all make bad decisions from time to time, or do things that our parents wouldn't necessarily approve of, and having a learning disability or any kind of additional needs doesn't take that right away from you. You still have the right to do that. So we do see it sometimes where a person with a learning disability has developed alcohol dependency, and the doctor has said to them, you know, you need to stop drinking, otherwise this is going to be detrimental. But if that person has mental capacity and chooses to go and buy alcohol anyway, you can't physically stop them from doing so, even though you know that that's not the best thing for them. If they've got capacity to make that decision, then they do have every right to do that. So it's a really important part of the Mental Capacity Act, but like I say, it is one that unfortunately sometimes is quite difficult to accept when you are trying to act in the best interests of somebody. The next principle of the Mental Capacity Act is that we act within the best interests of the individual without capacity. So if it is deemed that a person lacks mental capacity, any decisions made on behalf of them must be made within their best interests. So it does mean that we must consider the person's wishes and feelings, that we must consider the relevant circumstances, question whether or not the person will regain capacity, support the person's involvement, making sure that they have as much say as possible in this decision, and consider the views of those involved in the care, support and welfare of the individual. So when a person is an adult, whilst a parent does lose an element of parental responsibility legally, meaning that if they do have capacity, then you are not necessarily responsible for all the decisions that they make. You do have a right to be involved in their care and support without any kind of legal authority like power of attorney. So I will get onto this shortly and explain what your rights are. However, it is important that you are aware that there is no legal requirement for you to have any formal authority to be involved in decision making. So if a person lacks capacity, for example, every decision will have to be made within the person's best interests by making a best interest decision. And as this principle states, the views and wishes of those involved in a person's care and welfare, such as parents, should be considered. So this is quite prevalent in things like care and support assessments, so your needs assessments, anything where any decisions are made, whether this is how many carers they're getting during the day, whether they're going to live in residential care, any decisions whatsoever, you should be involved. There are, when it comes to lack of capacity, you can get independent mental capacity advocates if you can't come to an agreement with the local authority, for example. Every local authority will have like a designated advocacy service, whether that's voiceability, for example. There's power, there's multiple different agencies that local authorities kind of employ. You have the right to ask the social worker for an independent mental capacity advocate who can make sure that everybody involved is acting within a person's best interests. They're also really handy when there are perhaps safeguarding concerns, when you can't come to an agreement with the local authority. Advocates are really good at getting involved as well when parents aren't necessarily together and both parents are disagreeing with what is within the adult child's best interest. Advocates are really, really good there to make sure that people are acting within the best interests of the individual. So the final principle of the Mental Capacity Act is acting within, the decision is the least restrictive option. So what this does mean is that any decision made on behalf of an individual through the best interest process is the least restrictive option, and that the decision made interferes as little as possible with the person's rights and freedoms. So it's really, really important that the decision considers all the circumstances of the individual and that it doesn't limit their lives any more than is absolutely necessary. So for example, this could mean that when looking for a residential placement, if the person lacks capacity to choose, if you're faced with a decision between two different places, you would consider which would restrict them the least and which would interfere with their life the least. So option one might be a really, really good placement with a lovely garden and has a musical activity every week that we think somebody would enjoy. But option two is a good placement with a lovely garden. It doesn't have the musical activity once a week, but there are still other activities, but it's a lot closer to family and friends, has a more relaxed visiting policy. And if the person moving has a really strong relationship with their family and sees the family an awful lot, you would perhaps consider that that was in their best interest because it was the least restrictive option and was going to there wasn't going to be as much upheaval as there would going with the other. So I am now going to talk to you about how you can make decisions on behalf of somebody else. As discussed, there is no legal requirement for these to be in place for you to be involved. So the best interest decision will always or should always be made with you being involved. So with the parents being involved or anybody who is involved in their day-to-day care has that right to be involved. So the Mental Capacity Act sets out the legal ways in which people can gain a legal authority to make certain decisions on behalf of somebody else, particularly relating to finances. So managing someone's finances does become a little bit trickier if they're unable to do so themselves and one of these aren't necessarily in place. But like I say, you can gain legal authority for certain things. The three main ones are appointee orders, deputyships. There's two different types of deputyships, one for finance and property and one for health and welfare. And then finally, power of attorney. I will also mention guardianship because I think quite often people do get a little bit confused with regards to deputyships and guardianships and don't really know what the difference are. But as you can see, I haven't included this in this, and or will become clear there is a reason for that. So the first one I'm going to talk to you about is appointee orders. So you can apply for an appointee order via the Department of Work and Pensions. There's no cost to this, and it gives you the power to manage somebody's benefits on their behalf if they are unable to do so themselves. So the really key thing here is that you only have the power to manage their benefits. So the benefits would be paid into your bank account as their appointee. We always advise having a separate bank account, one that you keep your money in and one that their money is paid into. This we think is really important because it makes sure that you can track the expenditure. You don't run any risk of the money's getting confused, especially if you need to prove anything and you are just kind of prove that you are acting within the person's best interest to the DWP. If there's any confusion, any concerns, you have that there really clearly without having to work out which transaction was which. It is your legal responsibility to make sure that the money is spent within their best interests. So we do also advise that receipts are always kept. So again, you have that backlog, you have that paper evidence, you also have the bank statements, etc. Like I said at the beginning, appointeeship does not give you authority to deal with property and savings. So it's only advisable if somebody has no assets, no estate, no income other than their benefits. So deputyship. So a deputyship order can be granted when somebody lacks capacity to request that you act on their behalf via a power of attorney. So they must have already lost capacity in order to get the deputyship. So you apply for deputyships through the Court of Protection. There's a fee of £400. Most people that go through this process will also instruct solicitors to help them. But this can be quite complex and therefore it can become really quite expensive. But if somebody has an estate, any savings, etc., then a deputyship in this instance will be really, really beneficial. Deputyships for health and welfare are an awful lot less common. As I discussed earlier, whether this is in place or not, anybody who has any involvement in care and welfare, such as parents or carers, do have the right to be involved in any best interest decision, so it isn't always necessary. It's also worth considering that even if you do have a deputyship for health and welfare, most medical decisions would still kind of be made by the clinical lead or the consultant, but the parents would still be involved. So you don't need a health and welfare decision for, you don't need a health and welfare deputyship to make that decision. But even if you do, it doesn't mean that you get the final say. Everything still has to go through that best interest process. Deputies for health and welfare decisions are only really made in the most difficult cases, and the Mental Capacity Code of Practice does set out where this may be necessary. They're usually in place for important and necessary actions that can't be carried out without the court's authority, and there's no other way of settling the matter in terms of best interest, so if it is referred over to the Court of Protection. So some examples would include if there were a lot of welfare decisions that needed making, and it'd therefore be more beneficial to have this health and welfare deputyship in place than making lots of decisions in a really short space of time. Also, it would be that it's the most appropriate way to act in the person's best interest to have a deputy. Bear with me, sorry. So if there's not necessarily multiple relevant people that could be discussed. Also, a deputyship for health and welfare would be relevant if there was a history of serious family disputes that could have a detrimental impact on the person's future care unless a deputy was appointed, or the person who lacks capacity is felt to be at serious risk of harm if left in the care of family members. So in this case, like I say, it's very, very rare, but in these cases, welfare decisions would be made by somebody independent, such as a local authority officer, and they would perhaps have that deputyship to make sure that there were court orders in place to stop those people having contact if necessary. However, like I say, they are very, very rare because usually it would go through a best interest decision, and if there was ever a disagreement, regarding this best interest decision. If you don't ever agree with a best interest decision, you are able to refer it to the Court of Protection, and so a deputyship would not necessarily be needed. Deputyship is what people quite often get confused with guardianship. We do quite regularly get people calling, asking whether or not they need a guardianship or a deputyship. Guardianships aren't really prevalent in England. Guardianships are a lot more common in Scotland. In England, a guardianship really is only ever appointed if it is to do with mental health. Similar to, I think the best way I can describe it in a way that people would understand at the moment is similar to what is going on with Britney Spears. A guardianship is very much a case of when it is mental health in England. So we don't really deal with them at all because they don't really come into effect with people with learning disabilities. It would usually be a deputyship in every circumstance that required one. So the next one, as discussed, was the power of attorney. So a power of attorney is the final legal authority that you would perhaps consider. A power of attorney for property or finance or health and welfare can only be made by the donor. So the donor is the person whose decisions it involves. So for example, if it is your child that would have a learning disability, they would be the donor. They have to have capacity when making the power of attorney, and they would request that you act on their behalf, and therefore they register the power of attorney. There is a registration fee. You don't need a solicitor to be involved either, and more than one power of attorney can be appointed, unlike an appointee. You do have a requirement to follow the Mental Capacity Act, so the best interest processes will still need to be followed, but you can act before capacity has been lost. So usually power of attorney is put in place by somebody for if they were to ever lose capacity, but you can stipulate within the power of attorney that you want them to manage your finances. A power of attorney would often be recommended instead of an appointeeship if, for example, you did have savings, etc., but you've still got capacity and you want them to act on your behalf. If you're granted power of attorney for health and welfare, you can only make those decisions once the person has lost capacity, unlike the financial side of things. Okay, so this is more regarding the transition, so whether or not you should wait, whether or not there is any need to have this in place. So these are all things that you can think about before a child reaches adulthood. You don't have to have any of these in place either. Like I say, I think it is really important to stress that you don't have to have any of this in place. And I know I keep saying it, but I feel like it is something that quite regularly people do feel like they have to have, and they don't. Everything can go through a best interest process. There are also professional bodies that can take on the responsibility for you if you do think it is beneficial. So there are organisations such as DOSH, Pendrell's Trust, Money Carer. Quite often the local authority will act as appointee if needed to. It's not unheard of at all for people to want to use an external agency if they don't want to have the responsibility themselves. It can quite often be a really added stress, especially when people have other children, for example. Other people do like to do it as they like to be in control and they like to see what is going on. So it's really important that you just kind of work out what is best for you, rather than just feeling like you have to have one of these in place, because you don't. Like I say, you do somewhat lose parental responsibility at the age of 18. My parents can't tell me what to do, for example. It is very much a case of you live your own life once you are 18. However, in situations like this, when individuals do have additional needs, you can, if you don't feel like going through the best interest process is enough for you, you are able to apply for one of these. So that has kind of reached the overview of it. So what I have done for you is I've popped the details of the helpline on a slide for you. Any questions that I'm not able to answer, I can then kind of get in contact and let you know. And if there's anything at a later date, you can come back to us, no problem. But I hope that that has given you a good idea of what you can and can't do, and what is necessary for you, as I know it can be a really stressful time working out what's right.
Amber, thank you so much. That's been incredibly useful. I'm going to invite people in to see if you have got any questions. Please do put it in the question and answer box, or you can use the raise hand facility. What I do want to make clear at this moment is that Amber is, as it says on the Mencap, is the voice is for all learning disabilities. So please don't expect us to be able to answer questions that are specific to Prader-Willi syndrome, but certainly to give you a general understanding of, and I've got a question myself actually, Amber, and I think I did ask you this the other day, or I tried to ask you, but I've got two things muddled up. The difference between a lasting power of attorney and a deputyship. You may have covered it, but if you could just, what's the difference between a lasting power of attorney and a deputyship?
Okay, so a lasting power of attorney is something that you would put in place while you had capacity. So,
sorry, bear with me one moment. I'm so sorry. I'm having difficulty hearing you. Let me come out of this. I think everyone else can hear you. Bear with me one moment.
That's fine.
That's it.
Yeah, you good? Okay. So a lasting power of attorney is something that you would put in place while a person had capacity. So you see them quite often with people, for example, who have dementia, that they would put a lasting power of attorney. They would make that application while they still had capacity to say, once I have lost capacity, this person can act on my behalf. A deputyship is what you would apply for if somebody has already lost capacity. So Perfect. You quite often have it where people don't have any capacity, but they need support. So mum or dad or somebody would say, I want to apply so that I can make those decisions, but the person can't say yes or no at that point.
Thank you so much. I have got a couple of hands raised. If I could invite Katie Heel in, if you would like to come in and ask your question. Katie, are you there? If not, I'm going to move on to the next person that has their hand up. Okay, Laura, can we come to you? If you'd like to unmute yourself. Or could you unshare your screen as well, Amber? Sorry.
Yeah. Oh, how do I do that? There.
Yeah, just at the top.
Yeah.
Have we lost Fiona as well? Not Fiona. That wasn't who I asked. I asked Laura.
Yeah, hands have gone down.
Yeah. Laura, did you have a question that you wanted to ask? Both hands have gone down. Okay, we do have a question in the question box from Priyanka. Again, this may be a bit tricky for you to answer, Amber. Okay. Priyanka is asking, for my teenage daughter, what situations should I be thinking about putting one of these things in place? How do I know that I need them?
Okay, it depends on the circumstances massively. So, like I say, it's not something that I'd be able to answer as a general question. What I would potentially consider more than anything is a deputyship, not a deputyship, sorry, an appointeeship. When your child is at an age where they are claiming benefits, for example, if that was to occur, if they weren't going into work, they started claiming benefits but didn't have the capacity to manage the finances themselves, you can apply for an appointeeship so that you then manage them. We see them quite a lot if people go into supported living, for example, mum or dad or whoever would get a appointeeship, and they would make sure that all the bills were being paid, etc., and that the benefits were being being managed in the right way. So I would say appointeeship is probably best once benefits are being claimed, etc. But again, it really does depend on whether or not there are any savings, any assets or anything like that that need to be taken into consideration. But usually I would say appointeeship if the only thing that is relevant is benefits.
Okay, lovely. So you may have actually kind of answered this, but from our anonymous attendee, for a child of 16, what would be the best option to use in connection with operating bank accounts, a lasting power of attorney, or making a joint account with a parent, or the parent being added as a third party?
Again, it's really difficult when you don't know the full circumstances, but I would say if bank accounts already exist, you will have difficulty gaining access to any existing bank accounts if you don't have power of attorney or deputyship. Appointeeship doesn't give you the authority to access existing bank accounts. So if a bank account doesn't exist and it is a case of claiming benefits and managing an income that way, appointeeship will be fine. Anything else, if they have capacity to grant you power of attorney, I would do power of attorney, because that way, even if they do have capacity, it can be stipulated, like I say, that you can manage finances while they've still got capacity.
Okay, lovely. Has anybody else got any questions that they'd like to come in and ask? You can raise your hand or you can put the question in the question and answer box. I am aware that we have got a little bit of feedback, so I apologise for that. Would anybody like to come in? Anybody like to raise their hand? Oh, I've just been asked by one of my colleagues, actually, can you be removed as a power of attorney?
If you're not acting within somebody's best interest, then yes.
And what would the process be? Who would be the one to remove you?
The Court of Protection. So everything goes through the Court of Protection. If you have any concerns at all about anybody acting within somebody's best interest, whether that is power of attorney, deputyship, you would go to the Office of Public Guardian, who refer it to the Court of Protection. With appointeeship, you would raise it with the DWP.
Okay, perfect.
The question.
I've got another question from Priyanka again, who's asking, do a lot of parents create trusts to manage finances or inheritance? I'm not sure if that's one that you can answer.
Yeah, so people do that quite often. There are certain rules around it. We have a whole wills and trust department that deal with that, so I don't get involved in that at all.
Okay.
But they do it, but it is worth being aware of. There are certain rules to make sure that you're not what it's called deprivation of capital, where you are purposely putting things in a trust to make sure that they're not getting charged for care or getting charged, not going over benefit limits, etc. But it would be worth having a conversation with a financial advisor, or like I say, our trust department, who are really good at explaining all the rules to you there.
Perfect. And are they available on the helpline number that you shared?
Yes, if you come through the helpline, then yes, we can refer that over. That's not a problem.
Perfect. Can someone be a power of attorney if they live abroad?
I don't know the answer to that.
That's just stumped you, hasn't it?
Yeah, I don't know the answer to that. I want to say yes, as long as it's registered in the UK, but I'm not 100% sure on that. I'll find out.
Yeah, lovely, because the person that the power of attorney would be in relation to lives in the UK, but the person that's going to be the power of attorney is abroad. And is that something that can be done?
Yeah, possibly if they're a UK citizen, but I'm not 100% sure on that. So I don't want to say yes and it be wrong. So I will find out. I will make a note. Yeah, I'll find out.
Thank you very much. Thank you very much indeed. Anybody else? I can see that there are hands going up and then they're being taken down immediately. If none of you are comfortable to ask a question on camera or by coming in to ask it, then please just let me know. I'm very happy to ask on your behalf. Again, I've got a question from the anonymous attendee. I'm going to say straight off the bat, I think that this is too specific. I think it's too specific to PWS, but I'm going to try it anyway. They're asking who would establish that a PWS child has or has not got capacity. Okay.
Yeah, that's fine. It depends on the decision. So it depends massively on the decision. Mental capacity isn't a blanket assessment. So, for example, the examples that I was giving earlier of what you'd have for breakfast, if you're the main carer, you would decide whether or not they had capacity to make that decision. When it comes to granting power of attorney or deputyship, usually you would have witnesses sign the form that would say, this person, I believe, so in terms of power of attorney, where you have to have capacity, you would have somebody else sign the form. There's a list of who can act as witness and citizen certificate providers that are effectively witnesses. They would sign the forms to say, yeah, we are confident that this person has capacity. The same with deputyship, it goes through the Court of Protection. So there are rules in place to make sure that it is established that that person doesn't have capacity before you effectively sign their rights away to make their own decisions. So it does really depend on the decision. That's what a best interest process, etc., is for. In terms of medical decisions, it would likely be the clinical lead or the GP or the surgeon. So it really varies, but multiple people are involved. But that's what the Mental Capacity Act is there for, to make sure that processes are followed before determining that somebody doesn't have capacity.
Perfect. Lovely. Thank you very much. Would anybody else like to ask a question or come in and share an experience?